Tonight, new developments in the former president's New York civil fraud case. Trump requested a delay in paying the $355 million penalty, and now a judge has said no.
Two men, 11 years together, now on opposite sides of the most expensive civil fraud judgment ever handed to a former American president. One is on a campaign stage calling the system nasty and coordinated. The other is on CNN saying, plainly, they don't have the money. Which one is telling the truth? And what do these combined judgments, approaching $500 million, actually mean for Donald Trump? Welcome to Updates for Now. Let's break it down. Let's start at the rally. 3 days after losing the civil fraud case, Donald Trump chose to address his supporters in Michigan, one of the most competitive swing states heading into the 2024 election. The choice of location was deliberate. Michigan needed to hear from him, and what he chose to say tells us a great deal about his political strategy. Notice what he did not say. He did not say the judgment was legally wrong.
Crooked judge, crooked judge. He's a crooked judge.
He did not announce specific grounds for appeal. What he offered instead was a single, powerful political frame. I am being persecuted. The system is coordinated against me, and only you can stop them. The word coordinated is doing very specific work in that sentence. It takes every separate legal proceeding, the New York civil fraud case, the E. Jean Carroll verdict, the federal indictments, and bundles them into a single conspiracy narrative. It says, these are not independent courts, independent juries, independent prosecutors following independent evidence. They are one coordinated attack. The factual problem with that framing is straightforward. It would require a New York civil judge, a federal defamation jury, a Manhattan district attorney, a Fulton County district attorney, and 2 separate federal special counsels, operating in different jurisdictions, under different laws, with different evidence, to all be secretly working together toward the same goal. That is not how the American legal system operates.
No one has ever seen in this country before. That happens in banana republics. It doesn't happen in this country. The case is a complete and total sham. It's a sham case.
These outcomes are similar because the underlying conduct was examined, not because the institutions were coordinated. But at a campaign rally, the goal is not legal argumentation. The goal is political mobilization. And on that level, the message landed exactly as intended. On the same morning that Trump was processing that rally in Michigan, CNN brought in a guest who has a very specific and very complicated relationship with everything we just described, Michael Cohen. For 11 years, Cohen served as Donald Trump's personal attorney and fixer. He was not the CFO of the Trump Organization. That was Alan Weisselberg. He was not the accountant, but he was present for deals, present for conversations, and present for the internal operations of the Trump Organization in a way that very few people have ever been. Now, before we go any further, it is important to be transparent about Cohen's background because credibility matters in journalism. In 2018, Michael Cohen pleaded guilty to 8 felonies. Those included tax evasion, campaign finance violations, and making false statements to Congress. He lied, including under oath. He served prison time. Trump's legal team has used this history extensively to attack his reliability as a witness and commentator. We acknowledge that history. It is real and it is relevant. But here is the distinction that matters for today's analysis. What Cohen is saying about Trump's finances is not testimony about a specific event at a specific meeting that you have to take on faith.
It is my experience that Mr. Trump inflated his total assets when it served his purposes, such as trying to be listed amongst the wealthiest people in Forbes, and deflated his assets to reduce his real estate taxes.
It is a structural inference, based on 11 years of watching how this particular business operated, how it used debt, how it valued assets, how it approached liquidity. That is a different kind of claim, and it is one that, as we will see, was independently validated by the financial markets themselves. Here is what Cohen told CNN when asked directly what these combined judgments mean to Donald Trump. The death touch. That is a striking phrase. What Cohen is describing is the gap between 2 very different financial concepts, net worth and liquid cash. Trump's wealth has always been overwhelmingly tied up in real estate, properties that carry mortgages, management agreements, and existing debt structures. You cannot write a check from a building. You cannot post a Manhattan skyscraper as a bond overnight. To understand Cohen's point, look at how the Trump Organization has historically operated. The Atlantic City casino bankruptcies are the clearest example. Trump put minimal personal capital into those ventures. The businesses were heavily debt financed. When they failed, It was the bondholders and the banks that absorbed the losses, not Trump personally. The Trump shuttle airline followed a similar pattern. The contractors who were left unpaid over the years followed a similar pattern. The consistent thread across decades is this: Trump's approach to financial obligation has been to minimize personal cash exposure and find other parties to absorb the cost. Cohen's prediction that Trump would look to Republican National Committee funds, super PAC money, or asset liquidation is rooted in that observed pattern. Let's put the actual numbers on the table clearly, because they are significant. Now consider this. In February 2023, Trump told CNBC, on the record, that he had cash reserves in excess of $400 million. That specific claim became directly relevant when Judge Engoron's bond requirement was set. To appeal the fraud ruling while pausing collection, Trump needed to post a bond, initially set at approximately $464 million. If your stated cash position is $400 million and the required bond is $464 million, you cannot post the bond. The math does not work. And that is precisely what happened next. 30 surety companies, professional bond writing firms whose entire business is evaluating collateral, refused to write the bond. These are not political actors. These are financial institutions making risk calculations. They looked at Trump's actual assets. They assessed what those assets could support as collateral, and 30 of them said no. The appellate division ultimately stepped in and reduced the bond requirement to $175 million. A California auto loan financier named Don Hankey, through a company called Knight Specialty Insurance, posted the bond using cash collateral, not Trump writing a personal check. That sequence of events, 30 refusals, a reduced requirement, an unusual third-party arrangement, is the financial market's independent verdict on Cohen's analysis. Cohen said the cash position was not what it appeared. The bond market confirmed it. It is worth pausing here to be precise about what Judge Engoron actually ruled, because Trump's rally framing of nasty and coordinated has a way of replacing the legal substance with political noise. The civil fraud case brought by New York Attorney General Letitia James centered on the Trump Organization's statements of financial condition, annual documents that listed the value of Trump's properties and assets. Judge Engoron found that these statements consistently and significantly overstated those values, not by small margins, by amounts the court described as ranging from hundreds of millions to, in some instances, billions of dollars. These inflated valuations were then used to obtain favorable loan terms from banks and insurance companies. The court found that this constituted fraud under New York law, and that the profits gained through those fraudulent statements needed to be disgorged, returned essentially, because they were obtained through misrepresentation. The documents that Trump used for decades to project the image of extraordinary wealth, the same documents that built the brand, secured the loans, shaped the business, are the same documents that produced the judgment against him.
It was all about delay, but this is the plan to make that happen.
And there is a plan.
Yeah.
So the sources I've spoken with are saying that Trump really does not want these two federal criminal cases he's facing to go to trial. He has.
The myth and the liability came from the same source. Here is something worth understanding about how Trump has consistently translated legal losses into political fuel. In normal political circumstances, a finding of civil fraud would be damaging, perhaps disqualifying. But Trump's approach inverts that logic. Every new legal development, however damaging as evidence of misconduct, becomes, within his political framing, additional proof of the scale and desperation of the opposition. A larger judgment does not mean more fraud was proven. In this framing, it means the system is more determined to stop him. More cases do not mean more evidence. They mean more coordination. The self-reinforcing nature of this argument is what makes it politically durable. It is unfalsifiable within its own logic. And the Michigan rally, held specifically 3 days after the judgment in a competitive swing state, was not just a response to the legal news. It was a fundraising event, a political mobilization tool, and a message to his base that these legal proceedings should increase their loyalty, not diminish it. Cohen, watching this from the outside, does not engage with the political narrative directly in his CNN interview. He stays in the financial lane. And that discipline is actually what makes his analysis useful. It cuts through the political noise and asks the simple question: regardless of the framing, can he actually pay? At this point, it is important to tell you what happened after this February 2024 moment, because the story did not end where Cohen predicted it would. Cohen predicted financial destruction, forced asset sales, inability to meet obligations. The bond crisis confirmed the financial stress was real. But the full liquidation Cohen described did not materialize, for several reasons. First, the appellate division reduced the bond requirement significantly, from $464 million to $175 million, making it manageable through the third-party arrangement we described. Second, in November 2024, Donald Trump won the presidential election. The two federal criminal cases against him were subsequently dropped, as the Department of Justice does not prosecute a sitting president. The Engoron civil fraud penalty was later vacated on appeal. Cohen was right about the financial stress. The bond crisis validated his core assessment. But he was wrong in suggesting that financial pressure would be politically decisive. It was not. The voters heard both narratives, the legal accountability story and the political persecution story, and made their decision. So what does this moment, February 2024, Cohen on CNN, Trump at a Michigan rally, actually represent? It represents the clearest possible illustration of two parallel realities operating simultaneously in American public life. In one reality, a court system examined decades of financial documents, found them to be fraudulent, and issued one of the largest civil fraud judgments in American legal history against a former president. In the other reality, that same judgment was repackaged as evidence of political persecution and used to energize a campaign. Cohen, for all his complicated history, provided a window into the financial reality that most people could not see. He was right that the cash position did not match the claimed wealth. The bond market confirmed it. He was right that the number was too large for Trump's liquid asset. The 30 refusals confirmed it. What he could not fully account for was the degree to which political victory can insulate someone from financial and legal accountability. That is not a partisan statement. It is simply the outcome the record shows. The legal story and the political story ran on separate tracks in 2024, and they produced different results. That is our full breakdown for today on Updates for Now. A $355 million fraud judgment, a former president calling it coordinated and nasty, and the man who worked alongside him for 11 years saying plainly, they don't have the cash, a claim the bond market went on to independently confirm. Before you go, we want to hear from you. If you found this breakdown useful, subscribe to Updates for Now for clear, fact-based coverage on the stories that matter. We read every comment. We will see you in the next one.